Assalamualaikum warahmatullahi wabarakatuh. My name is Siti Nabiehah Binti Mohd Redzuan. My metric number 1201603. So today I would like to present about the book review entitled Resolving Child Custody Disputes, the Law and Practice in Malaysia. Okay, for the summary, this book was about the difficulty to resolve child custody disputes because disputing parties are equally competent to care for the child. And these challenges become worse in countries such as Malaysia, where there is a dual system of family law, which is one set of the laws and courts for Muslim and another one for the non-Muslim, which leads to a conflict of laws when the two parties to a custody dispute are not subject to the same sets of laws and courts. Okay, next for the introduction, there are three sets of laws in Malaysia relating to custody dispute resolution. The first one, federal laws; the second one, state laws; and the last one, laws that apply to only one of Malaysia's three main components. All of these laws, however, can be divided into two categories. The first one, the laws applicable only to Muslims based on Islamic law, falling under the legislative authority of each state and administered by each state Sharia courts. The second one is non-Muslim laws contained in pre-Malaysia statutes applicable to either Sabah, Sarawak or the then Federation of Malaya, or established by Parliament after 1963 for application through Malaysia. Okay, next, mediation as a means of improving custody disputes resolutions. The first one is mediation as a method resolving custody disputes has the potential to alleviate some of the challenges attached with such disagreements. The problem for each parents are legal fees, fears of losing custody or being caught in the middle between their parents. The second one is for family matters, particularly custody disputes. Training will need to be more specialized, taking into consideration the emotional nature of such cases, the specific skills that will be required to guide the parties in their discussions, particularly when there are power imbalances between the parties, whether those imbalances are in relation to expertise or knowledge or negotiation ability, or the gender issue of the man being dominant and attempting to intimidate for the women. Furthermore, about the custody of children under the Sharia, custody under Sharia, or known as Hadanah, is defined as caring for the newborn during the early years of life, when the infant requires a woman to look after it. All schools hold that the mother, whether separated or living with her husband, has first claim to custody of her child. This guideline is founded on the hadith from Abdullah bin Amr reported, a woman said, "Apostle of Allah, my womb is a vessel to this son of mine, my breast as a water skin for him, and my lap a cut for him. Yet his father has divorced me and wants to take him away from me." The Apostle of Allah said, "You have more right to him as long as you do not marry." So the last one is conclusion and recommendation. The resolution of custody disputes in Sharia courts requires only minor amendments to the law, but shows that procedures can be improved to reduce delays. The main problem with delays in Sharia courts appears to be shortage of Sharia judges, and efforts are needed to increase the number of appointments. Moreover, the resolution of custody dispute in civil courts has shown that some changes to existing law are necessary to clarify the application of the law to both ordinary or civil matters and dispute cases increase. Also needed is restructuring of the High Court, which deals with the custody disputes, so that custody cases do not have to compete with other cases to add hearings, thereby avoiding delays in deciding cases. And I think that's all from me. Thank you.